Hello, good day, everyone. Let's just continue our discussion. But by the way, I have to make a few review lang or recall of those concepts, lalo na sa essential requisites ng contract. So, we've known that the essential requisites of a contract is consent, object, and cause or consideration. So, consent refers to the manifestation ng meeting of the minds or meeting of the offer and the acceptance upon the thing or cause of the contract. Ano? So, we have as well when it comes to we have as well under 3019 kung ano po ba yung definition ng consent. So, alam naman natin na when it comes to consent that it is part of the essential element ng isang contract. So, under the essential elements, ito yung mga elements that should be present in a contract or else a contract could not be considered as valid. Ano? No contract can validly exist without the essential element. That is the consent, object, tsaka cause. Tapos, meron din tayong tinatawag na mga natural elements. Ano yung mga natural elements? Ito yung elements ng contract na even though it is not stipulated, not really expressly stipulated or stated in the contract, it is presumed to exist, in certain contracts. Let's say, for example, yun pong ating pong contract of sale. Kahit na hindi po stipulated na yung party has the right to convey the property or to transfer the property, it is presumed, given the execution of a contract of sale. At the same time, yung mga warranties din, warranties against eviction, warranties against hidden defects in the sale of a certain property. Yun yung mga sinasabi nating natural elements. Another thing is that yung tinatawag nating mga accidental elements. Ang accidental elements sa isang kontrata, ito yung mga particular na stipulations or clauses or terms or conditions established by the parties in the contract. Ito yung makikita natin sa Article 1306. Kung naalala ninyo, ito yung tinatawag natin ng na liberty to contract or freedom to contract. It means to say that all the parties to the contract have the freedom to stipulate or state that clauses and certain terms provided na hindi siya contrary to law, contrary to public policy, public order, etc. So, yun po yung atin pong mga elements na accidental. So, yun po Ano bang perfect example nito? So, yung sa accidental elements, halimbawa, contract of loan, pwede tayong mag-stipulate na meron pong babayarang interest, aside from the principal payment and the terms on how would be the payment be done or performance of an obligation kung meron kang mga conditions. So, po pwede yung ilagay sa isang contract. So, tawag natin doon ay yung mga accidental elements. And then, under 1319, we have the definition of what is a consent. So, basically, a consent, manifested daw siya by meeting of the offer and the acceptance upon the thing and the cause, which are to constitute the contract. The offer must be certain and the acceptance constitutes a counter offer. So, by this provision, we could readily see kung ano ba yung ang consent. So, dapat daw may manifestation na nagme-meet ang offer at saka nagkaroon ng acceptance upon the cause or upon the cause or consideration ng contract. So, here, as a requirement of consent, it must be, ang consent must be given by the parties, So, it should be something that is freely and intelligently given and it is expressly manifested of the will by the contracting parties. And then, as well, it should be that the parties, in order that they could give a valid consent, dapat din sila capacitated to enter into a contract. Another thing which is being mentioned under 1319, in order that masasabi natin na there is consent. So, i-requirement natin, concurrence, nagpanagpo dapat, present dapat yung offer, tsaka yung acceptance, So, ano ba yung offer? Ang offer, ito yung proposition or proposal made by one party to another, of course, to enter into a contract. Usually, this is your expression or your willingness to bargain or to enter into something that you as well desire. So, importante na ang offer daw ay certain. It should be definite, it should be specific para determined natin yung specific liabilities at the same time yung rights ng parties. Kaya importante po pag bibili tayo ng sasakyan, dapat alam natin how much for how much should be the offer. So, how much should be the amount? So, masasabi natin na definite So, let's say for example, I'm willing to sell my car to you for 100,000. So, that thing we could readily see that there is a definite na offer. Tapos, acceptance. Ano ba dapat ang acceptance? Ang acceptance daw dapat hindi qualified, dapat absolute. Kasi kapag qualified po ang acceptance, ang ating pong treatment diyan ay yun ay counter offer lang. So, ibig sabihin nito, kapag sasabihin po ng isang seller na, I am selling my car to you for 100,000 provided na may siniset pa siyang conditions and terms. So, masasabi ba natin yun na absolute? Well, hindi. Yun po ay isang counter offer na kung saan na-extinguish nga lang yung original offer ni offeror, and then not unless lang yung counter offer na which is a modification of the original offer ay accepted, saka lang po natin masasabi na nagkakaroon ng perfection ng contract. So, the contract is not perfected when the counter offer is counter accepted as well. So, yun po, importante po yun, And then, under 3019 as well, kapag nga naman daw, paano mo masasabi na nagkakaroon ng acceptance kapag ang acceptance ay through a letter pa or telegram? So, habang ang telegrama ng acceptance or letter ng acceptance ay nasakay ng barko, ng eroplano, or natakbon sakay ng truck, ay hindi po natin yun makakonsider na nagkakaroon pa ng acceptance. So, reckoning date pala, yung binding effect ng acceptance ay kapag lang it would reach or it came to the knowledge of the offeror. So, from that time, it came to the knowledge of the offeror. And then, at the same time, with regard to the time and place and manner of acceptance, usually it must be complied with before it is made effective. So, importante yun, And then, under 1322, kung naalala ninyo, sa atin pong na-discuss na way back 1327. And in 1322, if you could recall and have it in your book, sa provision po ng Civil Code, ang offer daw made through an agent is accepted from the time acceptance is communicated to him. So, ibig sabihin nito, kapag po nakikipag-usap tayo sa isang agent, masasabi ba natin, o kailan ba natin masasabi na paano pag ang offer nga is made through an agent? So, kailan ba ang contract perfected? Would it be despite that ang ating communications with the agent ay before pa yun nagre-reach dun sa taong nag-authorize sa kanya or sa kanyang principal, ay masasabi na nating accepted na yung meron na siyang knowledge dun sa iyong acceptance. Well, if the offer is made through an agent, the contract is perfected from the time the acceptance of the offeree is communicated to the agent. So, okay lang yun kapag kausap natin ng agent. Bakit? Before pa hindi siya even before it is being conveyed to the principal. Kasi, under the principles of agency, tatandaan natin, yung personality ni agent, extension na din yan ni principal. So, parang nakikipag-usap na tayo kay principal. So, that's the thing there. And then, in case man ang offer under 1323, provisions ng 1323, what would be the effect daw of an offer acceptance kapag daw may death, civil interdiction, insolvency, or insanity ng either party before po ng acceptance is being conveyed? Well, ang mangyayari po, the offer and the acceptance would become ineffective. So, yun po. And then, at the same time, ano pa ba yung mga instances na masasabi natin na yung isang offer ay ineffective? Well, usually, alam na naman natin to, yung hindi natin tatanggapin yung offer, di kaya man ay nagkakaroon ng qualification yung acceptance or merong mga condition pa siya. So, counter offer lang ang treatment natin doon. And then, kapag nagsiset po tayo ng period to accept the offer, tapos bigla namang nag-lapse yun, so ineffective na yung offer, ano. So, parang dun sa period na sana siya magkakaroon ng acceptance ay hindi po nila nagawa, edi mayari ay good as lapse na or panis na po yung offer, hindi na po pwede. And then at the same time, yung before pa nagkakaroon ng acceptance on the part of the offeree, ay nade-declare naman yung object ng contract na illegal or unlawful. So, hindi yun po pwede, ano. Question: when could we withdraw or revoke the offer? Po pwede ba yun anytime i-withdraw ang offer? Po pwede, provided na before the acceptance, ano, wala pang acceptance, ano, even before the period of acceptance has expired, po pwede yan. It is usually here while the tatandaan natin, provided na wala pa pong nangyayaring acceptance anytime, po pwede nating i-revoke or i-withdraw yung nagiging offer. And then 1325, 1326, tatandaan natin na yung mga business advertisements, yung nasa sa TV, ano, or sa ads for usually offering for sale, could consider those as offers? No. Yung sabi nga ng 1325, unless it appears otherwise, yung mga business advertisements of things for sale, hindi sila definite offers but mere invitations to make an offer. And then under 1327 daw, here, diba na pagpulungan natin, in order that you could freely give consent, dapat ay ikaw din ay may capacity to contract. Under the civil code, hindi siya nagbibigay ng specific enumeration kung sino yung may legal capacity. So, under the civil code, ang general rule ay lahat ay capacitated, ano, to enter into a contract. Ang exception lang ay nasa 1327. So, sino ba yung mga hindi po pwedeng mag-give ng consent under 1327? So, under 1327, ang mga unemancipated minors, insane or demented persons, ay hindi po pwedeng insane and demented persons, and deaf mutes who do not know how to write. Hindi po sila po pwedeng mag-give ng consent. So, here, ang emancipated minor, tatandaan natin, ito yung mga hindi pa po na-union nila na-reach yung age ng majority and still under the supervision of their parents, under parental authority. So, in the Philippines, we have 18 below, 18 years old ang atin po. So, we have as well age of majority the Philippines. So we have as well then those who could not give consent are those which are insane. So insane, very malinaw yon. Or demented persons. Ang issue lang natin is when it comes to deaf mutes who do not know how to write. Sila lang yung incapacitated, kasi if they know how to read and then of course but do not know how to write, masasabi natin na may capability na sila of understanding, therefore meron silang capacity to enter into contract. So tatandaan natin yan when it comes to however, when it comes to unemancipated minors, masasabi, may mga pagkakataon na despite though 18 years old and below nga, ay still masasabi natin na ang contract ay valid pero not until it is revoked. So ibig sabihin pala, yung mga kontrata na enter with as an exception to the rule that a contract entered into by an emancipated minor without the consent of his parents or guardian is voidable. So, meron po tayong exception. Ang una ha ay where the contract is entered into by the minor who misrepresent his age and applying the doctrine of estoppel. So, ibig sabihin nito, when an emancipated minor enter into a contract at sasabihin niyan siya ay 18 years old and above, ang kontrata ay valid pa din, ano. And then when the contract involves the sale of delivery of necessities to a minor. So, ibig sabihin nito, kapag si minor ay nabili lang ng mga necessary things such as yung gamit niya sa pang-araw-araw, yun ay mako-consider natin as valid ang contract. Here, if the general rule is that all parties are at the age of majority if both parties pala are at the age of majority, ang presumption natin ay capacitated, 'di ba? Yun ba yung right na yung capacity to contract or right to contract is absolute? Well, basically no. Kahit ikaw 18 pataas, may exception pa din. Kasi kapag kontrata ng sale na involve ay husband and wife, relates to their property, hindi yun po pwede. At the same time, yun po yung relationship ng guardian sa kaniyang sa property or sa property ng person sa under guardianship, 'di ba? Hindi rin yun po pwedeng magkakaroon ng sale. At the same time, yung executor or administrator doon sa estate na kanyang minamanage or yung estate ng namatay or property ng namatay, hindi dapat po nagkakaroon ng sale to him or to the executor or administrator. So, tatandaan natin. Under 1328, sinasabi dyan, here, under 1328, ang sinasabi ng 1328, contracts which are entered into during lucid interval are valid. Contracts during lucid interval are valid, and contracts agreed to in state of drunkenness or during a hypnotic spell are voidable. Ano ba yung voidable na contract or ano ba yung void ng contract? Ang void na contract, from the very beginning pa lamang, hindi na talaga siya valid. Ano? So, it could be na yung elements, isa sa mga elements ng contract ay hindi present or may problem dun sa elements ng contract or may issue dun sa may vitiation sa consent, ganyan. Pero ha, kapag voidable naman ang contract, ito'y valid not unless ma-declare siya na invalid. So, subject siya to ratification. So, not unless hindi siya china-challenge, ang contract na yun ay mako-consider natin as mga voidable. So, ano yung mga iyon? Or voidable or rescissible ang contract? Ano? Kapag po ang contract daw ay ini-enter into by insane or demented person during the time na siya ay nasa katinuan, lucid interval, yan ay valid. Tapos, contract kapag po ay during drunkenness, if there is a complete loss talaga ng understanding, then it is voidable. And then contracts which are entered into during a hypnotic spell. Ano yung nakaka-hypnotic spell? Kapag under ka ng inducement ng mga drugs, ano? So, yun po yung sinasabi nating voidable ang contract by reason of incapacity. So, under 1330, 1328, 1330. So, under 1330, a contract where consent is given through mistake, violence, intimidation, undue influence, or fraud is considered voidable. So, kasi po, under 1330, actually, it shows us ano yung mga vices of consent. Ano yung mga vices of consent? Dahil nga po, ang requirement po natin dapat, ang consent ay intelligently given, freely and voluntarily given, dapat conscious or spontaneous ang consent din na given. So, kapag meron po tayong mga vices or mga bagay na nakaka-taint sa consent, it would make the contract voidable. Ano ba yung mga iyon? We have 5 here under the enumeration of 1330. Ang sabi dyan ay mistake, violence, intimidation, undue influence, or fraud. Fraud or deceit. Ano? Yung mga vitiation sa contract. So, it affects the first essential element of contract, which is consent. So, here, the consent of the parties, well, is considered vitiated or tainted with any of the 5 causes as mentioned under 1330. Ano? And then, kailan ba under 1331 nga masasabi natin na vitiated ang consent under 1331, which is 1331 speaks of about error or mistake, ano? In order that, under 1331, in order that mistake may invalidate consent, it should refer to substance of the thing, which is the object of the contract, or to those conditions which have principally moved one or both of the parties to enter into a contract. And then, at the same time, mistakes, ang sabi din dyan sa 1331, mistakes as to the identity or qualifications of one of the parties will vitiate consent only when such identity or qualifications have been the principal cause of the contract. Ang simple mistake of account shall give rise to its correction. So, by this provision, with this provision, we could readily see kung kailan po yung error or mistake ay nakaka-apekto sa consent. Dapat daw substantial yung nagiging mistake or error, such that nakaka-apekto to or na it nakaka-apekto sa object of the contract, sa conditions which principally move the parties to enter into the contract, and then identity or qualifications of persons na nag-enter into contract. Kung natatandaan niyo, lalo na kapag personal obligations, diba? Usually, sa personal obligations, tatandaan niyo nag-enter into a contract because of the personal qualities of the person. Personal qualities of that person, why you hire someone, diba? So, like a singer, like a dancer, yung ino-offer kumbaga ay serbisyo, ano? So, yun yung nagmo-move sa atin para po tayo. Pero pag nagkakaroon daw ng mistake as to the identity or qualifications, it would basically vitiate consent only when such identity or qualifications have been the principal cause of the contract. Here, error or mistake. So, we have a definition. And then we have error of law. Error of law is a mistake as to the existence of a legal provision or as to its interpretation of application. So, here, tatandaan natin yung error error must be a mistake of fact, not of law. Kasi yun po yung nakaka-vitiate ng consent. Ano, hindi po mistake of law, but a mistake of fact. And then, let's go now for violence or fraud and intimidation or threat or duress as being stipulated under but going back pala, under 1334, ang sabi dyan, mutual error as to the legal effect of an agreement when the real purpose of the parties is frustrated may vitiate consent. So, ibig sabihin nito, ang 1334, ito lang, nagre-reiterate siya, inuulit lang niya yung question of law that becomes a question of fact kapag daw ang consent of the party is vitiated and will render the contract voidable. Dapat nga lang may mutual error, ano? And then, ang error ay nagre-refer dun sa legal effect ng agreement. And then, yung real purpose ng mga parties ay nafo-frustrate. Anong example nito? So, let's say for example, I offer to sell to you a diamond ring, ano? And then comes here, when you accept it, when you accept it, ang iyong understanding ay it is a donation. A donation by me. Although on my understanding, it is a sale. So nangyayari dyan, ang ating interpretation, wala talaga nagiging meeting of the minds between the parties kasi wala namang sale. Wala din namang donation. Therefore, masasabi natin na walang contract. So that falls under 1334. Let's have 1335. Ano ba yung violence? Kapag po nag-e-employ ka na ng force or physical force o di kaya physical contact between persons na gumagamit ka na ng coercion, yun po ay, ang tawag doon ay violence. So, to make the consent defective, the force employed must either be serious or irresistible. In either case, consent is not free. It means to say it's not freely given. So, such force must be the determining cause in giving consent to the contract. Ano naman ang intimidation? Kung ang violence ay nag-a-apply ng force, ang intimidation or threat, hindi naman po nag-a-apply ng force. Dito, internal siya. Ang violence po, tatandaan natin, external. Nakaka-vitiate ang consent po. Nakaka-vitiate ang consent. Ang intimidation, ito yung nagkakaroon ka ng mental coercion. Yung ika nga ay parang pambubudol. Ito ay walang force na ini-employ, kaso ang iyong tinitira po ay yung moral or mental na coercion. And then, dito, masasabi natin na meron pong intimidation in order to vitiate consent or taint consent when one of the contracting parties is compelled by a reasonable at saka well-grounded fear of an imminent and grave na evil. Yun yung sinasabi diyan na intimidation upon his person or upon his property or upon the person of his spouse, di kanyang ascendants, descendants. Yun yung sinasabi nating tinitrete natin or ni-intimidate or tinatakot na hindi natin ina-applyan ng force. So yun po, meron pong nade-develop na fear into that person, kaya po siya napipilitang mag-enter into a contract with you. So kung ang example nito ay para bagang sasabihin natin siya, pag hindi mo ibibenta ang iyong property, ilalabas ko, parang blackmailing, ilalabas ko lahat ng mga baho mo, o ewan ko, bahong kilikili, bahong utot, pero yun na po yung sinasabing threat or intimidation. Kapag naman violent, so syempre pwede kang tututukan ng baril or hahampasin ka ng bubugbugin ka muna. So yun po yung sinasabi nating tawag nito violence. So ano ba yung requirements for violence, by the way, in order that it would taint consent? So na may irresistible force, serious and irresistible force, and then that's the very reason why you enter into contract. So yun lang po another thing, paano naman kapag po ang violence or intimidation ay third person naman ang nag-e-employ who did not take part of the contract? Would still be the contract, would the contract be valid, or the violence and intimidation would annul the obligation? Well, by that scenario, it would basically annul the obligation. Kapag po violence or intimidation which is caused by the third person, ang classification natin dyan ay voidable ang contract because the consent is vitiated or vitiated. 1336, it's undue influence. Violence or intimidation, ito na yun. Undue influence under 1337. Ano ba yung undue influence? Dapat daw, under 1337, kapag daw there is, there's undue influence kapag si person takes improper advantage of his power over the will of another, depriving the latter of reasonable freedom of choice. So, the following circumstances shall be considered under 1337: the confidential, family, spiritual, and other relations between the parties, or the fact that the person alleged to have been unduly influenced was suffering from mental weakness, or was ignorant, or in financial distress. So, bale, ang basihan kasi ng article na to ay yung Article 24 din ng atin pong Civil Code, na lahat daw ng contractual natin or lahat ng ating mga property relations, kapag isa sa mga parties daw ay na-disadvantage on account na siya ay morally weak, morally dependent, mentally weak, bata, handicapped, o di kaya ay yun, morally deprived, ang mangyayari ay dapat siya ay may protection with the court. Ano ba ang mga requirement para masasabi natin na ang undue influence ay nakaka-taint ng consent, or nakaka-apekto sa consent? Dapat ay there is a taking of improper advantage, and then may over the will of another, and then yung person na yon ay nade-deprive na with the freedom to choose. So yun po yung atin pong pinaka-perfect example diyan.